You're listening to the Stable Management Podcast, where we discuss the barn management topics that you're passionate about.
Hi, everyone. Welcome to the Stable Management Podcast. Our goal is to bring you a real-world look into the parts of horse farm management that you love or hate most, such as stall bedding, farm equipment, and pasture maintenance. During each bi-monthly episode, we'll be joined by an expert guest who shares their experiences with and perspectives on an important stable management topic. This episode is brought to you by MaxiGlow Stabilized Rice Bran. The rice bran horse owners prefer is a superior performance supplement specifically formulated for horses. MaxiGlow is available in both pelleted and meal forms and is high in fat and protein, packed with antioxidants, controlled starch, and is very palatable. Right now, ManaPro is running a promotion for $5 off MaxiGlow, and the coupon is valid until December 31st, 2024. Please visit mannapro.com/promotions/max-e-glo to take advantage of this offer. I'm your host, Hailey Kerstetter, and today my guest is Rachel McCart, founder of Equine Legal Solutions. Thank you so much for joining me.
Thank you, Hailey and Stable Management, for having me. I'm honored to be here.
So we're going to jump right into this very important topic. And I'd like to know, what are some of the main liability concerns that farm owners should consider?
Well, for sure, human and horse injury are at the top of the list. That, as my veterinarian likes to say, horses are born and then they spend the rest of their lives trying to kill themselves. And so, it's every time I think I've heard every way that horse could possibly injure himself, I am corrected. So, it's certainly horse sports, are high risk activities, and when there are injuries, they're often catastrophic ones, and those are the things that tend to inspire people to sue over.
Yeah, that's I think it's something that people often think won't happen to them until it does. And then you have to start considering, well, it's more of a cleanup situation rather than being proactive and preventing a major lawsuit.
Yeah, I think that's right. And farm owners, can do three things to protect themselves. Number one, they can have strong liability releases that they have everyone who enters the property sign. They can, and liability releases do two things. They discourage people from suing in the first place because, the person says, well, I signed a liability release. There's probably not much I can do. And then they also, help the farm defend itself in the event that it is sued. Another thing that farm owners can do to protect themselves is to have robust insurance coverage, which doesn't discourage people from suing you, of course. Sometimes it does the opposite. But what it does do is pay for your legal defense in the event that you are sued. And that is really important because in the American system, unless there's a statute or a contract that says otherwise, everybody pays their own way in terms of legal fees in a lawsuit, win or lose. So if you're a farm owner, that means that you could easily spend tens of thousands of dollars defending yourself, even against the most frivolous lawsuit, with no hope of getting that money back. But if you have insurance coverage that will pay for your defense, that eases that concern.
Yeah, absolutely. So can you expand a little bit more on waivers and how they could protect farm owners from liability? I know you said it kind of deters people, but can you talk a little bit about how it might protect you if someone still chooses to sue, or what situations it can protect you in?
So the principle of what makes a liability release enforceable is called assumption of the risk. And what that means is that the person signing the release understood the risks of what they were about to do and agreed to accept them. So what makes a strong liability release is one that accurately and thoroughly and simply describes what the risks are. So I think we've all seen liability waivers that horse show entry forms are great for this one, where the liability release portion of the form is a paragraph in teeny tiny type, and usually it basically says horseback riding is dangerous. I agree to not hold anyone responsible if I get injured. That's a lot less likely to be enforceable than a liability release that lists the laundry list of things that horses can do that are dangerous, like bucking, rearing, bolting, stepping on people, that sort of thing. So one consideration that folks who are looking for a liability release often have is they don't want the liability release to be too long. They're concerned about how many pages it is, whether it fits on half a page. But I'm fond of telling people that when you are a defendant in a lawsuit, no one cares how long the liability release was. All they want to know is whether it says the right things to protect the person that the release was signed in favor of. So beware of the short and sweet release that it probably isn't descriptive enough of the risks to provide robust protection.
So can you talk a little bit in Pennsylvania, and I believe other states, but to be honest, I haven't looked hard enough at it. You'll see blue signs on people's farms that say basically you assume the risk associated with horse activities in accordance with Pennsylvania law. So what kind of weight do those hold in comparison to waivers? Should you have both? Is one enough? What are your thoughts on that?
That's a great question, Hailey. So the signs you're talking about, and a disclaimer here, I'm not licensed to practice law in Pennsylvania, but the majority of U.S. states now have what are known as Equine Activity Liability Acts. All of them are different from each other. Each state apparently thought it could do a better job in drafting its own legislation. So the wording of all of them differs. But what they do have in common is that the idea behind them is to help insulate people who are providing places to have equestrian activities, who are providing the activities themselves, to insulate those folks from what are considered to be the ordinary risks of engaging in horse activities. So that sounds great. And it does provide some meaningful protection. But all of these Equine Activity Liability Acts have exceptions to them. For example, most of them exclude horse racing. Most of them exclude people who are spectators. So, you could have an incident where, somebody was a spectator at a horse event and they got injured. The Equine Activity Liability Act might not apply. Some of them have requirements that in order to avail yourself of the protection of the act, you have to post signs, and the signs have to say certain things, and they have to be in certain places, and they have to be in a certain size typeface. Some of them have provisions that you have to include in your liability release in order to have the Equine Activity Liability Act apply. So there are lots of places for the layperson to go wrong in trying to avail themselves of the protection of these acts. I would advise equine facility owners to contact an equine attorney in their state to do a checkup of their liability releases and their signage and their policies to make sure that they're doing everything that they can and are required to do in order to have that act apply to them. So another thing to know about Equine Activity Liability Acts, they're not get out of lawsuit free cards. that what they do is provide you with a potential legal defense. As I mentioned, all of the statutes have exceptions. And so if you're doing something that isn't covered by the statute, it's not going to help you. And for that reason, you will want liability releases in addition to the Equine Activity Liability Act.
Awesome. So what are some other things that farm owners or managers could do to reduce their risk of lawsuits? Is having a boarding contract helpful, or cameras around the farm so you can support yourself in the event that someone does come at you with a lawsuit for something? Do you have any little additional tips and tricks besides the common waivers and signs?
Well, boarding contracts often include liability waivers. I know the ones that I draft do. So, again, you want to make sure that the liability release describes, pretty thoroughly the risks that you want the person to assume. So, for instance, a common scenario where horses get injured at boarding facilities is during group turnout. And so we get a lot of questions at Equine Legal Solutions about that, like, my horse injured another horse, am I liable? As a boarding stable owner, my boarders' horses injured each other, am I liable? That sort of thing. So, certainly as a boarding stable owner, you would want to think about, all of the risks of, ordinary horse type injuries and provide for them in your liability release. Another essential thing that every equine facility owner should do to protect themselves is conduct a safety inspection of their facility for both horses and people. That if you are running an equine business and you have people coming to your facility to participate in your business as customers, you have a duty to keep those people safe. And what that means is that if you know about conditions on your property that are potentially dangerous, you have a duty to either fix those conditions or adequately warn visitors to your property not to enter those areas. So, for instance, let's say that you've got a walkway between buildings at your property that has some loose boards, and you've known about it for a while, and everybody kind of knows the loose boards are there, but there's no sign. Well, one day somebody steps on the loose board because it's rotted, they fall through the walkway. That's the sort of thing where the premises owner, or if they're renting the property, the person conducting a business there, might be potentially liable to the person who got injured.
Can you speak a little bit about negligence in relation to both horses and their humans? In my very limited knowledge of this topic, I do remember learning about negligence, for example, if you put a rider on a horse that you know very for sure is too much for the rider and then they become injured. Is negligence something that you see a lot of, and how can people avoid a negligence lawsuit?
So that's a really good question, Hailey, that oftentimes allegations of negligence are the basis of a lawsuit. And suitability of horse and rider is a common area in trail ride, dude string type of activities, as well as riding lessons. That, the equine professional has a duty to consider, the temperament and abilities of the horse, and consider the abilities of the rider and attempt to make a good match. Of course, there are no guarantees in life, but, example where an equine professional might be found to be negligent is if they had, let's say, a young green horse that has a history of bucking, and they decide to pair that horse up with a less than advanced rider and not tell them about the horse's propensity to buck. That would be a situation where the equine professional might be considered to be negligent. So here's another avenue where negligence often comes up with equine properties, and that's horses getting loose out onto the road. That as a property owner, in most places, and I qualify that because there are some areas of our country that are considered open range land where free-ranging livestock has the right of way. That's not true most places, but the vast majority of in the United States, the property owner and operator has a duty to keep their livestock, including horses, contained on their property. So if the horses get out onto the local roadway and the horse gets hit by a vehicle, or the horse runs onto somebody else's property and causes a bunch of damage, the person who was responsible for keeping the horse contained is probably going to be liable.
That's actually really interesting that you bring that up because our last guest spoke about disaster preparedness, and she said the most common disaster that she deals with are all related to a horse getting loose. And she said people, especially near a roadway, and she said people often don't practice or prepare for what they would do in that situation, and it becomes a lot worse than maybe would have if they had been prepared. So I like that you bring it up from this angle as well.
Yes, good fencing, fencing and cross fencing and gates that securely close and latch, as well as training the people who operate your property and visit your property to close those gates behind them is essential.
This episode is brought to you by MaxiGlow Stabilized Rice Bran. The rice bran horse owners prefer is a superior performance supplement specifically formulated for horses. MaxiGlow is available in both pelleted and meal forms and is high in fat and protein, packed with antioxidants, controlled starch, and is very palatable. Right now, ManaPro is running a promotion for $5 off MaxiGlow, and the coupon is valid until December 31st, 2024. Please visit manapro.com/promotions/max-e-glo to take advantage of this offer. What are some common liability insurance options, and what types of facilities need insurance?
So if you are running a business from your property, no matter how small that business is, you need commercial liability insurance. And I can say that I don't sell insurance, I don't get a commission on it, but it's one of the most important things that you can do. Why is that? Again, because if you get sued, it can pay for your legal defense. So commercial liability insurance covers things like slip and falls in parking lots. It covers things like someone falling through the walkway on your property. What it often doesn't cover is damage to horses. And I say that, in terms of policy limits that, there are typically policy limits for personal property. And for the purposes of insurance, horses are considered to be personal property. There are usually also limits for personal injury, dollar limits, on how much the insurance company will pay out. So people who have horses on their property, let's say you are a boarding stable or you are a training facility, and you have some very valuable horses on your property where you could not afford to pay out of pocket to the horse owner if that horse got injured or died, that's a situation where you might want to consider requiring the horse owner to have their own mortality and major medical insurance on the horse. That you as a facility owner probably would not be able to insure that horse for mortality and major medical, but the horse owner could. And that would provide the horse owner a source of funds to replace the horse or to pay for very expensive veterinary care if needed.
Sure, yeah. I have a thoroughbred who I bought about a year ago now. And that's one thing that I looked into very seriously when I got him was major medical and mortality insurance, because it's another one of those things that you think, oh, it won't happen to me. I won't need this. Especially, he's young. He's only 8 years old, but you never know. And it's better to be safe, in my personal opinion, at least.
Well, and I think every horse owner has to evaluate that for themselves. That, I think the consideration is if you had an emergency, let's say your horse needed colic surgery, could you afford to pay for that out of pocket? Or would you be able to tap a source of funds that wouldn't bankrupt you to pay for it? And if not, what would your options be? That, those are considerations to think about when you're deciding whether you want to purchase insurance.
Sure. And what would you say for facilities that decide they would like to host events such as like a clinic or a horse show? Do they need different insurance, or is there normal insurance for just their regular boarding or lesson business suitable?
Well, I think, Hailey, that's a case-by-case scenario. And the smartest thing that the facility can do is to contact their trusted insurance agent and ask them that question. Like, hey, we're thinking about hosting X event. Is that something that our current policy covers? Now, you talk about clinics, oftentimes the clinician will have their own insurance. And so that's something that The facility that's hosting the clinic might require the clinician to add them as a named insured on their policy. So that if something happened during the clinic, it would hit the clinician's policy before it hit the facility's policy. Those are things to talk about with your insurance agent and come up with a plan, before you've got that event on the calendar.
Sure.
And certainly, again, you want to have everybody who sets foot on your property sign a liability release. The clinician might have their own liability release, but you as the facility owner don't have any visibility into how good a quality that release is, or whether it even protects you as a facility owner at all. That's a really important point about liability releases. Sometimes I see liability releases that people have DIY'd and they've cobbled together from, other people's releases or that they found on the internet. And upon reading the release, it turned out to be completely worthless because they left in the names of whoever the released parties were on the source documents and didn't change it to them. So great, they had everybody sign a liability release, but it releases some stranger that's not even involved.
Oh gosh. Yeah, I'm hearing a common theme is be proactive and consult an expert when in doubt, because this is so important that you get it right and preferably before something happens. Can you talk a little bit about the importance of finding an attorney who is familiar with the equine industry or maybe even specializes in that specifically?
I think that's vitally important when you're talking about drafting contracts for transactions in the horse industry and when you're talking about drafting liability releases, because an attorney who is familiar with the horse industry and hopefully steeped in the horse industry understands the unique nuances of transactions in the horse industry. Things like retained breeding rights, embryo transfers, all the things that might go wrong when you buy or sell a horse. Again, the risks of engaging in, horse-related activities. Your average lawyer who isn't familiar with the horse industry is not going to be aware of those things.
Yeah, absolutely. So unfortunately, we're already coming to the end of our time today, but I have one more question. It's something I ask everyone, and this is, what is one common misconception that you often hear about liability on horse farms?
Oh, that liability releases aren't worth the paper they're written on. That's absolutely untrue. That even the poorest quality liability release is better than no liability release. And, a well-drafted liability release that describes, clearly and plainly, what the risks are of engaging in horse activities, that is, hopefully particularized to the situation, will go a long way toward protecting the persons that are named in the release.
Awesome. Well, thank you so much for talking with me today, Rachel. This has been very educational for me, and I'm sure our listeners as well.
Thank you, Hailey and Stable Management, for having me.
Thank you all for listening today. Please remember to like this podcast, subscribe, leave a review, and recommend the Stable Management podcast to a friend.